Olá, bom
Hello,
dia a
good
todas,
morning,
bom dia a todos.
ladies and gentlemen.
Declaro aberto o painel
I
sobre
will
o
open this
fascinante
panel
tema da
regarding the
tributação
fascinating
internacional e tecnologias
subject,
disruptivas,
international
oportunidades e
taxation and
desafios
disruptive
para os países
technologies,
emergentes,
opportunities and
o
chances for
qual
emerging countries,
eu, Durval
where
Portela,
I, Durval
tenho a honra
Portela,
de presidir
I'm
com a
honored to
participação de
chair with the
professoras,
participation of
professores e
professors
profissionais brilhantes
and
para
brilliant
os quais
professionals
rendo
for
as minhas
which
melhores
I
homenagens.
render my
São eles:
homenages.
o
They
professor
are
Fernando
Professor
Zilveti,
Fernando
que é mestre
Zilveti,
em Direito Constitucional pela
Master in
Universidade de São Paulo,
Constitutional Law,
doutor
University
em
of
Direito
São Paulo,
Tributário
Doctor
pela mesma
in Tax
universidade
Law by the
e
same
docente
university,
em Direito Tributário pela Universidade
and
também de
also in
São
Tax
Paulo,
Law by the University of São Paulo,
professor do IBDT,
Professor of
nosso Instituto
IBDT,
Brasileiro de Direito Tributário,
Brazilian Tax
e o professor
Institute,
Zilveti vai
and
abordar o
Professor
tema do
Zilbert
contexto
will talk the
do
contest
metaverso.
of metaverse.
Na sequência, a
Following
professora
Professor
Tathiane Piscitelli, professora da
Piscitelli,
Fundação Getúlio
Professor of
Vargas,
GV,
coordenadora do Núcleo de Direito
Coordinator
Tributário
of Tax Law Center
do mestrado profissional da Escola de Direito, doutora e mestre em
by
Direito pela Universidade
Master
de São
by the
Paulo.
University of
A
São Paulo.
professora Tathiane
Professor
vai
Tathiane
abordar
will
o tema
address the subject
dos
of the
criptoativos,
context of
das criptomoedas.
crypto coin
Na sequência,
currency. Following,
apresentará neste painel
it will be
a
presenting this
professora
panel
Renata
Professor
Emery, que é
Renata
mestranda em Direito Tributário
Emery,
Internacional pelo
Master
nosso IBDT
in
e
International
coordenadora do
Tax
Grupo de
Law by
Pesquisa de
IBDT
Tributação de
and
Economia
Research
Digital
Group of
do
Taxation
IBDT,
Digital Economy of IBDT,
fazendo parte, pelo que eu sei,
being
de um
part,
grupo
as far as
já
I know,
totalmente
of a
dedicado ao
group
tema que será
fully
apresentado na
dedicated to the
sequência.
subject
E a Renata, ela vai
addressed
abordar
here, and
os
she will
aspectos
address the
relacionados
aspects
à
related
tributação de
to
robôs. Na sequência, a
robots,
professora Silvia
taxation.
Muñoz,
Then
que é
Professor Silvia
professora da
Muñoz,
Universidade
professor
de
of the
Lima,
University of Lima,
Legal Law Masters em
Legal
Tributação
Law
Internacional pela
Master
Universidade de
in
Georgetown,
International Taxation by
e que
Georgetown
vai nos
University,
apresentar o tema no
presenting as the
contexto das
subject within the
discussões
context
práticas
of
referentes
practical
a
debates
estabelecimento
regarding
permanente,
this
prestação de
permanent
serviços
establishment, rendering of
através de
services through
plataformas virtuais.
virtual platforms.
E
And
moderando esse painel,
moderating this
nós
panel,
temos o professor
we have
Erlan
Professor
Valverde, que é
Erlan
mestrando em Direito
Valverde,
Tributário
Master in
Internacional pelo
International Tax
IBDT,
Law
com
by
especialização em
IBDT
interpretação de
with
tratados
expertise
pelo
specialization in
International Bureau
treaties
of Fiscal
by
Documentation,
International
o
Bureau of Fiscal
IBFI, de
Documentation,
Amsterdã.
IBDF
É um
of
painel que, sem
Amsterdam. This
dúvida,
panel,
nos
there's no
fará
doubt,
refletir
will
sobre
make
a
us reflect on
necessidade,
the need
talvez, de uma disrupção
of
no
a
nosso sistema tributário
disruption of
nacional,
national tax law,
que ainda está na dimensão
that it's
analógica.
in the
Essa é uma questão
analog
para ser abordada,
dimension. The
trabalhada no
subject
painel.
must be addressed by
Eu
the panel.
gostaria de lembrar
I
que
would like to
cada
recall
dos painelistas
that
expositores
each
terá 20
panelist will
minutos
have
para a sua
20
exposição.
minutes
Por
to do
favor,
your
observemos esse
presentation.
tempo. Após o
Please
quê,
let's
teremos a moderação
pay
do
attention
painel
to this. Then we have the
conduzida pelo
moderation
professor
conducted by
Erlan.
Professor
Com
Erlan.
isto, eu
With
agradeço a
this,
presença de todos,
I thank
rendo
your
mais uma vez
presence
as minhas
and I
melhores
render my
homenagens a todos os
honor
nossos
to all
painelistas
our
e
panelists.
passo a
And I
palavra
pass the
ao
floor now
professor
to
Zilveti.
Professor
Muito obrigado.
Zilveti.
Good morning to everyone, and it is a pleasure to be here talking in this Congress, and I appreciate everyone that have organized this Congress with so much competence. I greet my colleagues of the panel, Orla, Durval, Tathiane, and we have been working for quite a while and discussing this topic of the novelties regarding technology. And Silvia Muñoz who has brought her amazing work with IBGT, and Renata Emery as well. She's more professor than student, whom I have the honor to work with her in my master's. I'm going direct to our topic now, and which is metaverse. Within this topic of metaverse, I would like to state that any opinion regarding how taxation should behave regarding metaverse seems to me a bit hasty, because, as I'm going to explain, it is important nevertheless regarding technology, what has been discussed in this respect and advancements, the speed of the technological transformation and the effect of these transformation in the social field demands from the countries, from the state, an effective action regarding legal security and mainly foreseeability. We have to treat thinking regarding these aspects, regarding legal security and foreseeability, and things that are legally effected and projected that can count on some sort of foundation so that we can understand the economic effect and how your business is going to work in the field, both national-wise and international-wise. So we are here talking about a new issue that's being developed, but not so new, I believe 15 years already. It has recently boosted. We're going to talk about a topic which is very easy to understand, which is the Second Life game or the Fortnite game, my children's games, Minecraft, and so on, for us to understand that the universe we're dealing with, we are working in another universe that brings together digital reality and physical reality, which seems to us that we are in another world. We're discussing something about this other world, and it's so very distant and far from becoming a reality for all of us. But this is once again a hasty conclusion, and it's not in line with what we really want to say. So firstly, we'd like to align the understanding of what is metaverse, which is basically to work with augmented reality, virtual reality, 3D technology, and also data. What we're doing today with the object of an article written by Alessandra Bach, which are digital congresses, and they talk about digital event, which is a recent article published by Alessandra Val. And she's very active, and I like her very much. And we have to think that today we are practicing one of the points of metaverse, one of the aspects of metaverse. But if we put a 3D pair of glasses and we work with augmented reality, we're talking about metaverse, Google. So what really matters here indeed is that in this universe, we are working with two main actors, talking about parallel realities, which seems a soap opera, but these are parallel reality because we have the real reality, the real world we live in, and the virtual reality, which is metaverse. In this world, we have two main actors, which are both the tokens as well as the blockchain. Tokens, I'm not going to advance a lot about this because Tathiane is going to talk about this. These are NFTs. They are tools that make everything possible with what we talk with respect to Web3 and virtual reality, both in terms of certification and transparency, and also efficiency, and why not say in the collection itself. So we're working here with an element which is very important, which is blockchain, which is the environment of certification, certainties, property. We're going to talk a lot about this to count on with legal security, and we're working with these tokens. These are the two important points that we're going to talk about with respect to metaverse. Now, to reach to this point, we have to imagine that there has been an evolution in the last years with respect to the traditional way of understanding property. There is a gap of understanding to follow what is traditional property, and now we're going to talk about virtual property. So there isn't a competition in this respect. There's no competition. No, saying we're going to only have virtual property or just the traditional property. There's no competition in this sense, okay? We don't even consider this competition. But with regard to international treaties, we must raise the debate for us to understand what is the center of our question here. First thing is the taxation. And when we refer to taxation, what are we going to tax? What for, and to whom? So now, with respect to metaverse, there is an economy. There is an economy which is tokenized, so to say, the token economy. And within this economy, we have to advance of what is going to be taxed. So we're going to think if we're going to tax the income, the economy, and also if we are going, now we're talking about real economy. So we're going to talk about also, we're talking about the digital economy to get to the real economy. When you are in the metaverse, you are in the virtual economy, but it has to be taxed through the real economy. So then the gap begins. The need of changing the traditional notion to the updated notion of the traditional issues so that we can advance of what is being understood as virtual property. If we advance regarding the virtual property, we can then converse in the international treaty environment how this thing is going to function with respect to what we have today. There is a constant question regarding the contracts of what is being discussed in the field of the virtual economy metaverse, and these form a jurisprudence and an understanding of what can be what is in fact property, equity. And if we're really talking about equity or property, how this new business that occur every moment in metaverse, and if these businesses have relations with income, consumption, and property or equity assets. So here we're talking about a constant activity where we see in the environment of metaverse, but that there's been a lot of noise in the real estate field. When I mention real estate, I'm talking about the real estate of metaverse, and people think of the real estate. This is our reference, of course, but there's been a great advancement in the acquisition of property or of assets. But this advantage is the virtual property, but we think of the real property because when you purchase a property in metaverse, it's got to do what Tathiane said. We talk about NFTs. We have to tokenize these assets, and so that they can be in the field of property as it is known. And this property, this asset, it has to have elements that gives me a foundation or a condition of regarding it as an asset, so that then we can see if there is an income, consumption, or indeed an asset. So this issue involved transparency, and once again, the need of working with treaties so that this transparency can appear. And in face of this challenge, you can raise the debate with respect to pragmatic issues, and so that what we think in terms of what is being created in terms of data can be both with respect to assets and also artistic property, intellectual property, and how we're going to treat this property, and if this property will be subject to taxation, which would be with respect to this asset property or this. So the hasty treatment leads to a simple discussion, but necessarily adjusted. So, which would be the environment of the rendering of services, because those who are the owners of the transactional environments of metaverse regulate the property within or the asset within the metaverse environment. It's as if we said that the asset or the property is not it does not have a public certification, but it has a private certification, which got to do with the gaming. And they would be in the field of the rendering of surfaces. Therefore, the operation of rendering of surfaces are easily understood as those that are already regarded in the world as the world of consumption. If we were to think in this manner, we will not be relating everything that I mentioned about the asset, traditional property or asset, but there is a rendering of service. The owner of companies that render services and making platforms available for the interaction in this metaverse environment. If there is such service rendering, which is a question, and if there is an environment, a simple environment where the integrating parts can transact and develop their economic activities, as is the example that I gave with respect to Second Life, which is a platform that allows you to be an owner, that you can negotiate the assets, the electronic assets, the digital asset within a virtual reality. And this transaction produces effects in the traditional reality. not in the virtual reality, but in the traditional reality. So within this environment, if we think that we are talking about services, creation of data, creation of content with this presentation, the other presentation, others that are to come, we're talking about services, digital content created, and the treatment of the consumption tax. If we say that everything is summarized as digital content created, we are rendering services and giving intellectual property or allowing the use of the economic rights of the use of intellectual property, and on doing so is object of taxation by the IR, the income tax, and be it royalty as well. And in this environment, we need to work in order to understand, and based on this apparent global rupture, the countries will have to first negotiate how to deal in certified environments, tokenized environment with blockchain or with NFTs, so that you can guarantee transparency in the operations, and that these operations, be it income, consumption, or assets, can be seen by all the contracting jurisdictions, so that you can maintain, you can have security with what is being transacted and collected. So, optimistically speaking, the NFTs and blockchain, they allow us to go to a new phase of negotiation, and also checking or the interpretation of the existing treaties. There's no need to make new ones, but so that we can see safely what tax is pertinent, or what relationship, if it's more related to income or more related to consumption. The trend is to be more related to income, but this obviously is quite polemic, but the tokenized transactions and that are made available by NFT are important to determine what will be negotiated and taxed from then on. Therefore, the application of the treaties regarding residents, people, individual, the place of the renderer of service, the consumer as well, and talking about events where it is taxed and the place of the consumer that happens in Europe, then you would have the ability to identify tax, and also you can have the credits for that consumer, so that collecting entity can identify both the wealth, tax it, and renounce when are the case, waive when are the case, if is the fact. These concerns that I have brought here will contribute within this historic period we're living, how to raise the debate regarding these issues, and those that will come after me in their presentation may clarify before the debate, so that we can evolve in this respect. Thank you very much.
Muito obrigado,
Thank you
professor
very much,
Zilveti.
Professor
Eu
Zilveti.
passo então a
I
palavra para
pass
a
the floor now
professora
to
Tathiane.
Professor Tathiane. Tathiane.
Muito obrigada,
Thank you very much,
Durval. É um
Durval.
enorme prazer
It's
estar
a
aqui com
huge
todos,
pleasure
com
to be
todas.
here
Inicialmente,
with
então,
you
bom
all.
dia.
So to
Agradeço
start with,
muitíssimo
good
pelo
morning. Thank you
convite
very much
do
for
IBDT
the
para estar em mais este
invitation of
congresso e
IBDT
ao
to be
lado
part of this
de professores
Congress
e
and
professoras que
with
eu admiro
professors
muito
that
e como o
I
professor Zilveti
hugely
falou, né, com quem eu já tenho
admire as
mantido um
Professor
diálogo
Silveti.
intenso
I have
a
had an
respeito da
intense
tributação da
dialogue
economia digital.
regarding
Então,
taxation of
a minha fala aqui, eu não
digital
sei,
economy.
acho que não está
Today,
em
my
tela
talk
cheia, Erlan. Aliás, também
my
agradeço aqui
talk today.
pela
Thank you very
mediação e
much
pelo
for the
controle dos slides.
mediation
Talvez
and for those controlling
se
the
desse para
slides.
colocar os
I
slides em
would
tela cheia,
ask them
talvez
to
fique
put in
melhor.
full screen mode,
De todo
please.
modo,
Anyhow,
enquanto a gente,
while
obrigada, resolve essa
we
questão operacional,
solve
eu
the
vou rapidamente
operational
apresentar
side
então o
of things, I
objeto
briefly
da minha fala.
present the subject matter of my
O
talk
professor
today.
Zilveti, ele trouxe aqui
Professor
uma
Zilveti
visão bem
showed us a view
compreensiva a
which is
respeito do
quite
metaverso e dos
comprehensive
problemas que se
regarding
colocam,
metaverso and the
especialmente no
problems
ambiente
arising
de
from it,
direito
especially
tributário,
regarding tax
internacional,
law,
como isso se
environmental,
relaciona com os
international or
tratados e
not,
como
and
a
how
gente
to
pode, e
relate
eu
with
acho que isso
treaties, and
Durval,
how can we,
professor
and I
Zilveti, da
would
sua
say,
fala é muito
Professor
importante no que
Zilveti,
se
what
refere
you
à
mentioned by the
transparência,
end, how
né?
to,
Eu devo
it's
muito a minha
regarding
fala assim também,
transparency,
porque acho que o nosso
because
grande
I think the
desafio para
biggest
além da qualificação
challenge,
jurídica, né?
it's
Claro que é
beyond
relevante,
legal
é a
qualification,
fiscalização.
it's the
Como
supervision,
fiscalizar essas
how to
atividades, como
supervise these
assegurar que de
activities and
fato a
ensure
capacidade
that in fact
contributiva
the
que se revela nesse tipo de
contribution
atividade, que ela está
capacity
sendo
in this type of
adequadamente
activity
captada. Acho que essa
is being
é uma grande
correctly
questão a
collected.
respeito da qual nós devemos refletir.
Disregarding the
Mas
point we must
para então
reflect on.
avançar
In
de
order to
modo
move
pouco mais
forward in a way
específico
which is more
nessa pauta,
specific in this
com olhar
agenda, with
para os criptoativos
eyes
no
towards
contexto do
crypto
metaverso,
actives within the
então eu vou
metaverso
só
environment,
apresentar
I will
aqui
just
ou
present you
retomar alguns
or
conceitos
resume some
que o professor
concepts that
Zilveti
Professor
trouxe
Zilveti
exatamente para
addressed in order
contextualizar
to put
em que
within the
momento a gente
context
pode falar
when
de
can we
criptoativo ou
talk
mais
about crypto
especificamente de
assets,
criptomoedas, de NFTs, olhando para essa realidade do
cryptocurrency
metaverso. Então, se a gente
through the
pudesse passar para o
metaverso
primeiro
reality.
slide,
So
acho que não
the
deu certo
first
colocar em tela cheia, mas
PowerPoint,
tudo bem, a gente
it's
pode
okay
manter
like
assim.
this. We don't need to be in full screen. It's
Erlan, a gente
okay.
pode ir para o próximo slide. Para mim não está mudando. Não sei se para vocês.
Erlan, could you go to PowerPoint or slide
Se alguém
2,
pudesse me
please?
sinalizar.
Não mudou, Tathiane. Só um pouquinho.
Vocês descontem isso do meu tempo, hein? Porque, olha,
So
estava programada
don't
para
compute this delay on my time,
Cuidando.
please.
Eu acho que o Erlan ainda não. O Erlan está tentando.
Acho que agora sim, talvez.
Agora
Isso,
sim.
excelente. Muito obrigada. Então vamos lá. Muito obrigada.
So, thank you very much. So,
Debate, né, sobre
all
tributação de
this debate
criptoativos,
regarding
ele
taxation of crypto
pode agora, né,
assets
diante dessa
can,
dessa
through
evolução que a gente
this
viu nos últimos
development
anos e
we are
dessa
evidencing during the
imersão
last
e
years and the
desenvolvimento do
immersion and
metaverso, ele pode
development
ser
of
situado
metaverso
exatamente
can
nesse
be
contexto.
placed exactly
Mas para
within
isso a
this
gente precisa
context.
entender então o
For
que é
this
o
purpose, we
metaverso.
must understand what's
Não há
metaverso.
ainda consenso,
Still,
né,
we
muito
don't have a
discriminado sobre
consensus
uma
very
conceituação do
precise
que seria o
regarding its
metaverso, mas
concept.
para
But
fins de
for the
simplificação, eu
purpose
diria
of
que o que é uma
simplifying things, I
experiência
would say it's an
virtual
experience,
coletiva.
virtual
O professor
collective
Zilveti trouxe alguns
experience. And
exemplos e eu
Professor
trago aqui
Silveti
outros, né?
presented some
Acho que o
examples,
Fortnite é um
and I
grande
have
exemplo,
mine.
né?
I
Que
think
está na
Fortnite,
casa de quem
it's
tem filhos, né?
in the
Está dentro da
house
casa
of
de quem tem
those
filhos
who have
com muita
children,
frequência. E aí
and
o
it's
exemplo que eu trago aqui
frequent.
do
And
Fortnite,
here
para
I
além
bring a
do jogo,
Fortnite.
foi
In addition,
evento
for the
recente que
game, a
aconteceu
recent
dentro da
event
plataforma, que foi um show
within
da
the
Ariana Grande,
platform
que
that
milhões de
Ariana
pessoas
Grande
participaram.
show,
E
many
havia, e eu sei
attended,
porque meu
and
filho
I know
participou,
because
então
my
havia
boy
uma sala de
attended.
espera
There was
e
a
as pessoas se
waiting room.
encontravam ali
People
no
met
lobby do
there
show,
at the
depois
lobby
ingressavam
of the show, and then they
neste
entered
show, então
this show
viveram
of Ariana
efetivamente uma
Grande. So
experiência
they
virtual
experience a
a
virtual
respeito da
experience
participação nesse
regarding
evento.
the
Outro
attendance to this
exemplo,
show.
que é de outro
Another
jogo também, é o
example
Roblox.
is
O Roblox,
Roblox.
ele se aproxima do
Roblox,
Fortnite
it's
nesse aspecto
close
de
to
ser essa
Fortnite in
experiência
this aspect of
virtual
being
coletiva em
virtual
que os
group
avatares se
experience.
encontram. E
Avatars
agora,
meet,
muito recentemente,
and
a
now
Nike acaba
recently
de
a
inaugurar uma
Nike
loja no Roblox que
inaugurated
possibilita que as
a
pessoas
shop
comprem
making possible to buy products of Nike. I don't want to qualify. You can buy a cap, T-shirt, sneakers for the avatar of the game. So if, of course, this is not a physical buy, it could be in the metaverse of universe, but this is for to illustrate your avatar, and your avatar will have the instruments and specific characteristics proposed by the shop. Another example, this is the most didactic one, in my opinion, to understand the dimension of metaverse and can it work in the future. It's a film for young people by Spielberg, Game Player Number One. It is by a book published during the 80s. And in this film, the fight is surrounding metaverso, illustrating very well to understand what's about. This is the fact of having you have gloves, helmets, clothes, so you enter the digital universe and interact with people and feel the interaction physically. The film portrays this very well. And then you can think, Tathiane, this isn't the Spielberg film, but what I see in the virtual environment, digital environment, correctly, with specific clothes to feel things. And in fact, what the debate on this subject shows that we're not that far. This apparatus exists. This is the last post of Bill Gates' blog in 2021, where he says, today, specifically with the pandemic, we do meeting through Zoom 2D format. We are in this Congress together due to technology. And then he says, but also in 2-3 years, perhaps it will not be this scenario. Perhaps we will hold the same meetings, congresses in the metaverse with these instruments that permit a different interaction. In addition to the one we have today, you have the physical interaction toward digital world and close to actual world. In this environment, it has an economic capacity, which is important. Recent report by JP Morgan shows that the forecast, the assessment is that there will be a $1 trillion market in metaverso, pointing as a data that yearly $54 billion expense in virtual assets or goods within the context of metaverse. This leads us to a second thought, how these transactions take place. And within this context, 2 points are key here. First, cryptocurrency, which are usually the mean of payment used within the metaverse context, and NFTs, these tokens non-fungible, they represent a title of property for a certain digital. It's an instrument for digital assets. So to face tax issues with this reality, it's key to set forth how taxation of cryptocurrency is made under development license in Brazil, and how can we use structures existent to use for NFTs, which is a bit recent, and I will talk about it recently or later on. So it's important to try to consolidate these instruments in one definition. And the definition would be of crypto asset. And this crypto asset definition on the previous slide, it is about a document published by OECD. It's not that recent. It's published in 2019, 2020, dealing exactly with taxation of virtual currency in different countries. So it's resume a summary and in definition of crypto asset. The definition is quite wide, including in also the NFTs. By the end, in the last paragraph, it says, nevertheless, the term crypto asset is commonly used to refer the types of digital financial asset. This expression is used ordinarily to refer to digital financial asset types based on distributive blockchain. Distributed is a clear example of this, of cryptography. It's part of the inherent value of this asset or good. Wide definition encompassing cryptocurrencies, which are based on the distributed record technology, including NFTs, also are recorded in one blockchain, that it points out to one certain digital asset. It's not just like the cryptocurrency. Important to mention that this definition of OECD, as I said, wide, it's not coincident with the definition that we have in our in-house specification, specifically regarding the instruction 188 of 019 that sets forth the federal taxation is disciplined by it regarding crypto assets. And in this sense, it's a very interesting article by Daniel Paiva Gomes showing clearly this limitation of the concept of crypto asset by the inland revenue of Brazil, because for them, crypto asset would be solely the asset or the financial asset qualified as is with a own measurement unit. In this sense, we have Bitcoin, Ethereum, other cryptocurrencies. In this case, NFTs apparently would be out of that definition of the normative instruction 188 as mentioned. Anyhow, to move forward in this debate, we must go look how to tax cryptocurrency in Brazil and how can I tax the NFTs in the light of the Brazil's inland revenue. So, next slide. According to Brazil's perspective, what we have is the qualification of cryptocurrencies, looking for the first block as a financial asset. It's equivalent to financial instrument. Everybody knows for years we are addressing this point, but the duty of the holder of the cryptocurrency to state the ownership of it, and when it is transferred with profit, it's raised as capital gain, as disqualification of financial asset. One notices in many other countries. So I'm the second column: Argentina, Brazil, Croatia, Denmark, Israel, Japan. All these countries classified as financial asset or financial instrument or asset, while others now we have a division classified simply as intangible asset. But it's within this umbrella that countries position themselves, and Brazil is here in the middle amongst these divisions as financial instrument or asset. And there's no doubt that I must state, and I will collect income tax over it. The doubt we have more in terms of argument than normative is regarding taxable events. When you look at these events, what do we have in the context of a cryptocurrency? We have the exchange for an asset or service, Bitcoins, to buy the Tesla car. I can have the exchange by currencies for dollars, or I can exchanged by cryptocurrency to cryptocurrency. Inland revenue position is saying that all these events are taxable in Brazil, and it will always happen on the optics of income tax on capital gains. So this picture here from the OECD report, the most countries tax all. Brazil is in the list. Any sort of exchange or use of cryptocurrency will be taxed. When I exchange for service and assets, in addition to capital gain, I will have taxes being levied on the acquisition of goods. They will not have the tax on the circulation of goods, but there's the stand by the state of São Paulo Inland Revenue saying that over the cryptocurrency, we don't have the tax on services, but the economic transaction, I'm buying a car, yes, I will have the tax on services. What's not clearly solved in Brazil, and here we can debate if it makes sense or not, exchanging crypto for crypto, for income tax, once it was not paid in, let's say so, I don't think it should be levied taxes, but there is no clear position regarding the event of mining. When we look mining, and because countries have to have a stand on this subject, we see it's a bit different on qualification of cryptocurrencies. We have certain uniformity or even taxation of the events I listed. When we look mining, we have a bigger division, and then we notice that Brazil is not in any of these charts. We have cases of taxation at first, when you receive currencies due to mining, or there's a second possibility when you transfer, then you have taxation, or different solutions when different countries, and Brazil has not positioned when we have some uncertainties legal wise in Brazil. And even concerning mining and the debate of cryptocurrency, it's not overcome. There are many points that must be dealt with yet. And yesterday, the Senate approved what it's the regulatory landmark of cryptocurrencies. But according to the light of taxes, we have a sort of norm consensus. It's not in doctrine or regarding the taxes being levied. But now regarding NFTs, first thing to understand, what are the NFTs? What are they? Some examples. The first one, the little girl with this devilish look, and the house is in fire. So this is a meme. And the person, the girl today, she's grown up. What did she do? She transformed this meme, this picture of her in front of this house in fire, in digital asset and NFT. There's one record for this file and is in blockchain. And then she got this record and is selling it for $500,000. The person who bought the NFT has the ownership of that digital asset. That's why it said NFT can be qualified of a property document. So it's the universe of metaverse art, but within this context, I can acquire an asset, a real estate, let's say, through NFT, and then I have the transfer of this property. Now, another example regarding art, it's regarding this art sold by $70 million. It was all-time record in the world of arts. Again, it's a digital one. And then we have several examples, and I could not list them all in this slide. The first tweet, it's another one transformed in NFT and was sold by 2.9 million, a digital art. And also the columnist of New York Times, and she's transformed her column in and she transformed an NFT and sold for $563,000. And there are two NFTs, works of art, but for 6.6 million, board Apple, and games and things of NFA. So we have here, in truth, good digital goods being traded. And so the properties or deed of these goods, it's shown through one record of that asset in the blockchain. So it's not fungible. I cannot exchange by a similar one. One record regarding the meme of this girl, or one of the first tweet. Nevertheless, the next example or PowerPoint. NFTs, are they crypto assets? Again, it's key regarding its qualification, legal qualification as crypto assets, especially in Brazil in the federal scope. Again, according to OECD definition, it could be qualified as crypto asset. According to the our inland revenue or Brazil federal revenue, Comes article, it's not being qualified as crypto asset because it doesn't have immunity. According tax light, in spite of the forecast of the normative instruction and its definition 18.188, what would be the crypto asset in spite of this Q&A of today's Brazil federal revenue for income tax return? It's defined as crypto asset, and so it's an asset that must be declared subject to the rules of income tax applicable to crypto coins. Crypto, if there's transfer with profit, you have to pay income tax on capital gain. In spite of all of the discrepancy in the norm regulating practice, I have a guidance by the Brazil federal revenue. It's a crypto active. I expect you to state it and to collect taxes if you transfer to someone. This is important in the tax on circulation of goods. So if treated like this, the NFT cannot be a digital asset because we have the circulation of goods taxes being levied, so it's more broader, the field. So, and I have doubts as it dealt of a electronic file, a digital asset, unique, and I transfer the property. And then we can say, if we have more time regarding the agreement 106, how effective it is to regulate this type of scenario, because the decision of the Supreme Court that deals with the agreement is a decision focused on software programs. Therefore, the circulation of goods levied, there's the argument because property is not transferred, because this is a license for use. In this case, if there's true the transfer of property, the NFT, Board A, is from Neymar and the New York Times column. So I can cogitate the ICMS, the circulation of good taxes being levied, but there's a treatment that's given this institute. Let's say the Brazil federal revenue can contradict for being levied the circulation of good taxes. Just to go to the last slide, as I said at the beginning, clear that we have a huge challenge on the legal qualification of it, because it's a new reality, and technology clearly will not wait for law. Transactions are happening, and one must, in fact, make feasible how to capture the contribution capacity of these activities. But the biggest challenge is also the supervision. How ensure supervision of taxes that will be due in this case once we define which one they are. So we have a public consultation to think about the model of rendering of information by the exchanges and institutions that do activities with crypto assets, similar to CRS regarding exchange of information in a way that we could have access to the data and go forward with the transparency and the public in consultations up to 29th of April. I think this is shared regarding digital economy as a whole. As I mentioned several times, the national standards were thought looking at the financial institution as central, that centralized transactions and possibility of supervision. OECD 019, the one when we talked about FATNA, established by 08 by USA, we don't have the bank confidentiality. We will see the exchange of information amongst countries regarding financial transactions because that's central entity. That's why I can do it. What characterizes the market of crypto assets as the supervision? So in face of a huge challenge, which is the possibility to supervise these activities and the true collection of taxes and economic capacity. So we have huge debates surrounding it, more questions than answers, no doubt. And I would say that the environment like this is important for us to develop in this agenda, posing the right questions. These were my remarks, and thank you very much again for the invitation. The next slide, my data, and I'm available for future interventions, and thank you very much.
Thank you, Professor Tathiane. I would like to remind the audience that you can send your questions through our Q&A here on the bottom of your screen. Professor Erlan will then organize them so to be made to the panelists. Renata, you have the floor now. Good morning, Durval. Good morning, Professor Zilveti, Tathiane, Silvia Muñoz, Erlan. It is a pleasure to be here with all of you this morning, being part of this panel with amazing professor, and to discuss a little bit about the future of collection or taxation, which is the common goal, is to debate the situations that are not in the norms yet, and we have to think about it and the future impacts and the possible change in our legislation, according to what Professor Durval mentioned, to reflect these new situations. And it is within the scope that we're going to chat briefly about what seems distant, but we're going to see that it's not. So this is which is the taxation of robot, automated structured, and AI. Thank you, Durval. This debate has already been done by the Academy and by government institutions for a few years already. We have seen the resolution of the European Commission of Civil Laws with respect to robotics and other studies that dated from 2016, 2017, and this is a topic that has been a topic of the Academy for quite a while, with amazing work like Professor Silvia Muñoz regarding the proposal of the taxation of robots, for robots. The term itself requires a definition because it's already being discussed, but we have to understand it in a more broadening manner, since we are aware, but to cover all sorts of automated machines and structures, and the use of AI, which has throughout the last decade replaced human work. What we have seen is a concern that is seen already with regard to the international, the convention model of the UN, when it proposes a new Article 12b that's got to do with the taxation of services rendered by automatized structures. The federal revenue, the Brazilian federal revenue has already qualified these services as technical services in the normative 1445 of 2014. So the concern is indeed present, and what matters is that we must evolve in this debate. And this arises because of the fourth industrial revolution that was defined by Klaus Schwab in 2016 in the World Economic Forum as being a revolution through which virtual and physical systems would then cooperate among themselves, between themselves, in a flexible manner and global manner as well. This replacement of human work by machines has been seen in the industry, replacing repetitive functions and even those that could pose danger for human beings. And now we see a new moment where machines are replacing human services and activities regarding the use of technical knowledge, and also machines that learn and develop automatically, which we call machine learning, and which shows limited potential of this artificial intelligence AI replacing human beings in intellectual activities which were specifically reserved for people. All this technological development brings legitimate concerns on behalf of the government, on part of the government, with respect to the relations of consumption, employability, and the impact, be economically wise or taxation wise. Now, the European Council estimated up to 2030 we'd have 2 billion job vacancies which would be closed because of the replacement by machines. The World Economic Forum, in a similar study, estimated 1 million job vacancies. These figures vary significantly. We have studied that contest these studies, and also they say that the creation of new positions to be created throughout time. But there is a very legitimate concern on part of the government that maybe these vacancies, job vacancies, wouldn't be enough to then cover this enormous contingency of employees in the following years to come. With this, we now raise the question, at a moment where we'll have a bigger number or a bigger group of number that will need public social assistance for example, unemployment fund, training, healthcare assistance, and then we're going to have an enormous decline, on the other hand, of the contribution for our social system. The drop of income of individual generate impacts in the collection of the income tax, and also in the drop in consumption, because without income, people do not purchase or consume, and machines do not consume. So generating huge concerns with regard to all the impact, the taxation impact, not only with respect to IR and social contributes, but the collection of consumption or the taxing of consumption. Next slide, please. So, in face of these concerns, government and the academy itself has discussed a lot what would be the alternatives, pros and cons of establishing taxation of these automated structures in AI and robots. One of the proposals, the Professor Xavier has done a lot of work on this matter, suggests that we should attribute a legal personality to robots, and this discussion already exists for other legal effects, not only with regard to taxation. An interesting example is the case of Sophie, so that in Saudi Arabia, it was she was attributed a citizenship. So this discussion already exists. If these robot structures should be applied to them a legal entity, so that they can be subject to rights and obligations. And this discussion that exists today goes beyond the taxation matter, case where we can have robots subject or passive individuals of taxation. Now we pose another question. Even though the robot could become a passive individual or of legal taxation, because by law he would be attributed a legal entity because of taxation, how could I then see how they could contribute, because the robot does not receive any pay? So then we have to attribute income to the robots. And here we see there is an enormous discussion with respect to how much, how, and at what extent would it be possible to apply this income so that the robot can acquire contribution capacity for taxation goals. So another less disrupted proposal, maybe more closer to our reality, it's got to do with the taxation of the legal entity that employs automatized structures and artificial intelligence in its activities, and it suggests that a better profitability and efficiency should be captured and taxed, like a top-up on the IR, something created for this end. But nevertheless, we also have challenges in the sense that it becomes difficult to calculate what would effectively be this extra or additional profit that could be or would be produced by these automatized structures and robots. Another proposal suggest that they should limit taxation because it's got to do with the expenses related to these machines. This proposal talks about a public policy for the use of, for not incentivizing this technology to postpone this process of replacing the human labor in comparison with the technology. With respect to other proposals, they want a differentiated taxation with respect to consumption, which we call RIT, which could be reflected in the state tax and ICMS, and the possibility of creating an income over the assets, which would be for robots, like, for example, which we call IPVA, or any tax that could be levied because of this occupation. Then we would require a reform in our constitutional system. And other proposals say innovative proposals, which would constitute in the creation of specific taxes for taxing AI and robots, something like more specific for the use of these equipment. These proposals, next slide, please, they face critics to the taxation of artificial intelligence and robots by the academy. If we have on the other side Robert Shuley and also Bill Gates that advocate to this, that today the employees are subject to taxation on income, and also companies and also contribution for social security regarding the employees. And with the replacement by robots, then the robot and the company should compensate or offset this loss in income by a tax that replaces replaced by these structures, or at least to offset them. Critics to these proposals, they indicate the possibility that any sort of taxation should have a reverse effect, which is precisely the impact in competition, not only with respect to this company, but the country itself, internationally wise. All this taxation of technology could not only reduce the speed at which the country implements and develops its technology, as well as it cannot not being able to compete in the international environment with competitors of other countries do not have implemented. We have not implemented this same form of taxation. Therefore, even those that advocate the proposal, they call attention for the need of an implementation in a very coordinated manner of each kind of taxation over the automatized structures, robots, and AI. Besides this, critics to these proposals, they put into check all this discussion and the data regarding the growth of unemployment, the rise of unemployment, and they say that new professions will be created, so we can have a reverse effect, in fact, and also the growth of the inequality regarding this technological development. This set forth what we see in the Brazilian scenario is the inexistence of any proposal or bill of law, formal bill of law, that has covered these issues. There are studies being conducted and that have discussed the possibility of how this taxation could be implemented. And one of the discussions that seems to me more interesting and is following the pathway of our constitution, thinking the possibility of the institution of a contribution of intervention over the economic aspect, which would be specific for our social security and could also be destined for educational programs where they could then retrain the workers that lose their positions and jobs because of this process of automatization of our economy. This proposal, although we already see a pathway within the constitutional text, it raises the same concerns that were put forth by the critics of the taxation of the robotization. The main one refers to the international competition that Brazil could then lose in case it adopts in an isolated manner a taxation of these business and structures that use automatization structures, which will affect our technological processes, where Brazil would then delay this process of automation. So now I bring forth these considerations. I believe this aspect of taxing automation and the digital aspect is important. Society has to think about it. Projections are very at long term. We have seen impressive figures of unemployment, potential up to 2030, 8 years from now. And this imposes to the society the reflection of these impacts and begin as soon as possible the discussion about the potential solutions that can be implemented to deal with these issues. Durval, thank you very much, Professor Renata. I now pass the floor to Professor Silvia.
Olá, Silvia.
Hello, Silvia.
Oh, hello.
Estamos te ouvindo e te vendo perfeitamente.
It's my audio okay? Hello?
Yeah, it's fine. We can hear you. We can see you.
The problem is that I cannot listen anybody. I think there is some technicality. Well, but if it's okay with my audio, and I think, is it okay? Yes?
Yes.
Thank you very much. Well, good morning, everybody. First of all, I want to thank the IBDT for this kind invitation to participate in this new edition of the Congress. In this morning, I would like to share with the audience some reflections about the recent importance to the provision of services through electronic means and the new debate that we anticipate regarding the treatment of new business models based on cloud computing. I would like to present the Peruvian experience in these two issues, considering our previous last years living digital services with the income tax. Maybe we can go to the next slide. Thank you. To start with, a short background. In 2004, the Peruvian legislation introduced a drastic change in the income tax law applicable to services provided by non-residents. At that time, an important proliferation of electronic commerce transactions had already been identified, specifically in the mining sector, as well as the use of internet used to carry out services with Peru as destination without the need for physical mobilization of the provider's personnel. The Minister of Finance considered that it was necessary to expand the tax base by reaching operations that under the traditional source rules, as those based on physical presence, would escape the Peruvian income tax. In addition, it was recognized that the source rules included in the Peruvian law, all them based on physical presence, were incompatible with the development of electronic commerce at that time. A fact that was finally confirmed over the years. In this way, in 2004, a drastic reform was approved in the income tax. Income from services were basically identified in three categories: services in general, where human activities is essential, digital services, and technical assistance. And a new nexus was created for digital services under the principle of the market country, specifying that this country would be the one where the services is economically used. The foundations of this treatment were focused on the work made by the OECD in 2003, and specifically on the United States sales tax precedents on sales tax. Considering these elements, Peru's right to tax would be based on the benefit that the location of Peruvian consumers generated for the seller or provider of services, being Peru the country that would have provided opportunities as a destination market. As you can see, this treatment for electronic operations was approved 15 years ago, and of course, before the development of Pillar 1 of the OECD, which has similar foundations. Maybe we can go to the next slide, please. Erlan, maybe the next slide. Thank you. As the slide shows, the income tax on digital services levies on the provider's gross income at a rate of 30%. It is applicable to B2B and B2G operations, but not to B2C transactions. And it taxes all digital services, even when the provider business is not a highly digitalized business, and even when the provider's line of business is not the development of technology. For the income tax, a digital service needs to meet certain requirements. But the problem in Peru has been, what is considered a service for income tax purposes? This has been a subject of intense debate here in Peru, because the income tax, unlike the VAT Act, does not contain a definition of this type of operation. Despite this lack of definition, it's understood that a service is an operation that entails an activity and a to-do, as opposed to those operations that consist in the giving or delivering of goods. In terms of electronic operations in the country, a very important distinction was made to establish that the term digital services are different from digital goods, category that comprises mainly goods such as books, photographs, music, or other goods that can be distributed through the downloading. Well, this distinction of course, has not been easy over the years. And in the last years, case law has been very diverse. On the other hand, as the slide shows, the income tax regulation introduced some specific examples of what the legislator considered a digital service, such as online customer support, data warehousing, online auction, online education, online games. Based on this design, two important problematic issues have been recently discussed in the country as potential contingencies in the future. The first one is related to the fact that the digital services that are taxed with income tax must be automatic, or what is the same, require minimal human intervention to be provided. Notwithstanding this, the Peruvian tax regulation expressly points out as an example of digital services those professional consulting services provided by doctors, lawyers, engineers, or other professionals through email, video conference, or other remote means of communication. I don't know if we can go forward. Next slide, please. Indeed, in this situation, the question that arises is whether services where human participation is essential can end up qualifying as digital services for the sole fact of using an electronic medium based on an electronic network as a mere communication instrument. This problem is exacerbated when analyzing these services that are often now provided through software platforms such as the ones we're now using, like Zoom, WebEx by Cisco, or Microsoft Teams. The service rendered in such a way should be considered as a digital services. And in relation to this issue, a second problem arises, which is the characterization of the income generated by new digital business models, especially those that come from the cloud computing business. Next slide, please. Regarding the first problem, in 2018 and 2019, the tax court resolved two disputes related to services provided from abroad using email that were qualified by the tax administration as digital services. In 2018, the tax court ruled in favor of the taxpayer. It was a Spanish company that provided administrative services, treasury, computer assistance, etc., from Spain to its Peruvian subsidiary. The Spanish workers used email to communicate with the Peruvian user, as well as telephone calls. SUNAT, the tax administration, considered that the digital services had been provided, but the tax court ruled against the tax administration opinion, indicated that email had been used as a mere facilitator of communication and cannot be considered as a digital services as the Income Tax Act regulates. Although the income tax regulations refer to this type of operations, one of the requirements set forth by the same regulation is that the service needs to be automatic and not feasible in absence of information technology. In the case, it was shown that the service could be provided by different means of communication. Therefore, it could not be qualified as digital service. In 2019, another controversy was also brought to the tax court where engineers for a multinational mobile device sales company provided their Peruvian customers technical support through email. The essential human presence in the service caused that the tax court disregarded the transaction as a digital service due to the lack of automaticity. The thing here is that the fact that of the email is a mere technical tool that facilitates communication among the parties of the transaction shouldn't be the reason to categorize the operation as a digital service. Despite these precedents, the regulatory tax norm here in Peru continues to establish that the services provided through remote means of communication, such email or video conference, are digital services, which generates, of course, contingencies in operations of this type in the future. I'm not sure if this is the case in Brazil, but this is an important issue that now is under discussion in the tax arena here in the country. Maybe we can move forward. Thank you very much. Another problem is the characterization of income generated by new digital business models that were not considered by the Peruvian tax law of 2004, which had in mind those services that had physical servers instead of the cloud servers that are more common nowadays. We can classify the digital business models, as the slide shows, in 4 types: platform-based models, content-based models, models based on cloud computing, and models implemented in life and business, and that is referring specifically to Internet of Things. For this presentation, our interest is in the models based on cloud computing, including SaaS, software as a service, IaaS, PaaS, CaaS, FaaS, and SaaS, that are all the classification that the scholars and the IT area has divided regarding the cloud computing model. The most representative category of this type of model is SaaS, which is defined as the capability provided to the consumer in order to use the provider's applications, including networks, servers, operating systems, storage, or even individual application capabilities, running all of these on a cloud infrastructure. Examples of SaaS are Zoom, Dropbox, and Zendesk. Certainly, cloud computing-based models have redefined the way business is carried on, since there is no need to make huge investments in IT areas, and applications are accessible from anywhere and anytime. But how to characterize the income that comes from operations qualifies as SaaS? Income from a service, from the lease of some equipment, or royalty for the right to use the hardware or software of the provider. We can go to the next slide, please. The United States approved in 2020 proposed rules to its income tax regulation that divided the treatment into just 2 categories: income from services or income from lease. It will be treated as a lease if, among other requirements, the service recipient is in physical possession of the property or controls the property. Instead, it will be treated as a service if, among others, service provider has the right to replace the relevant property, or the fee for the service is based on a measure of work performed rather than the mere passage of time. The court cases has also analyzed this problem, and as the slide shows, I present here a recent Indian case. The Indian precedent is Rackspace, where a USA company earned income from cloud services rendered to Indian residents. The tax authorities consider that the operation should be treated as a payment of royalties from India. However, the Court of Appeals ruled in favor of the taxpayer. This court considered that there was no grounds to conclude that a royalty has been paid. The income cannot be categorized as royalties, said the court, because the term use or right to use means that the payer possesses the property and it is at his disposal, which was not the case. In that case, the customer did not have physical control or possession over the servers. Also, the right to operate and manage the infrastructure vested solely with the non-resident taxpayer. And finally, the customers were not even aware of the specific location of operation of the server in websites, webmail, or etc. In Peru, the debate is open regarding this issue. First, it's important to identify if certain products qualify as SaaS. For example, Zoom, this platform that we are using now. If that qualifies as SaaS, it should be noted that the fact of representing a means of communication should disqualify Zoom, WebEx, Microsoft Teams, or other networks such as this as a digital service for Peruvian perspective and considering the recent tax precedent. I want to finish my presentation with just one question. Is this will be the same in Brazil? Is this will be the treatment that tax authorities will have regarding the electronic means of communication and software or this business models based on cloud computing? In Brazil, it will be the same, and that maybe is one question that we'd like to raise for the panel, because it's important to take into account that Peru and Brazil have a tax treaty that has a special clause for digital services, and of course, it was introduced to the treaty under the petition of the Peruvian authorities because our tax legislation. Thank you very much.
Thank you so much, Professor Silvia. Erlan, por favor, sua moderação.
Please, your moderation now. Thank you, Durval, and all panelists for this fantastic presentation of subjects that are very important. We are dealing with it in our tables IBDT, and these subjects are very important and address. It's interesting to see how this Congress, when you have new technologies like metaverse and so forth, it's inaudible, the sound. The Q&A section, it's very interesting. Talking about metaverso, cryptocurrency, I would like to pose a question, Professor Tathiane. The sound, it's really, really inaudible. I'll do my best. When we're having the use of assets, could it deem it's a taxable event? So a bit of spice to the question, because many attorneys at law on intellectual property have difficulties of attributing what be the rights linked to this type of transaction. Is a commercial transaction, royalties collection, and so forth. So Professora Tathiane addressed to you directly this question. Thank you very much. Thank you very much, Erlan, and those who posed this question or questions. The time per se, because this is a tax event, it does not seem, because I have the creation of the digital asset when we do the tokenization, thinking about an NFT. There's a New York Times column. The columnist decided to record and have one digital record of this column, and it became NFT. So she's the holder of the asset, and therefore trying to enforce our rules. She had a duty to state this asset when made available. When she transferred to someone, then we could think about levying taxes, but at the moment of the true creation of NFT, it seems to me no. In this case now regarding rights, we have to assess the content. What is it about when we think NFT, the type of right use and type of association made with it. It's an artwork, it's intellectual property, or the column per se, a picture, and then we must see the content per se of the asset created. Is it clear? Very interesting. Some lawyers of intellectual property, they say NFT with bragging rights. So bragging right, I'm sorry, you have the right to state you're the owner. It's just, some say bragging rights. Very interesting. So some IP, intellectual property attorneys at law, they say this. So in fact, we have to see very well placed at the beginning of the panel and questions. Now, the other issue was related by Diogo, if the fact is complemented by the generating event. So we think of levying it, tax on the circulation of groups, ICMS. It's inaudible. I'm very sorry. I cannot hear him.
Cortou sua fala, Erlan. É para minha pergunta ou?
Isso.
Well, therefore, we must see the change on the complementary law. This is a debate very interesting because, in fact, it was faced by the Supreme Court when it assesses the 106 agreement in some sense, because the Supreme will set forth when it's assessed the computing program assessment, because it's a digital asset per se, would not prevent ICMS to be levied, but in that specific case of computing programs and regarding the availability of cloud programs, ICMS taxation would not be possible because there's a lack of the transfer of property. So on the legal situation of this asset, I have doubt. It's an argument to say there's no way out and the ICMS tax would be a physical. If there's a physical movement, it can be levied, but we must think about the arguments presented by the Supreme Court that recognize the possibility of levy the ICMS on digital assets. In spite of the provisions of a complementary law, this would not have been a problem of 1945 that assessed the agreement. Now, my first impression would say, in spite of being impossible to confirm a thesis on this argument, would be that no, we did not have to change the complementary law because this way I understand the case law overcame the fact of needing a physical movement, recognizing the possibility of taxation of ICMS on digital goods and assets that check this possibility of having or not the ICMS on NFT, depending on the legal qualification and the federal way of seeing things.
Now, with respect to Renata's presentation and attribution to legal entity, sorry, I cannot hear him. If there were... Sorry, I cannot hear him well. To legal entities should be given to a robot. What are your thoughts about this? Olá, Erlan. I think it's a very specific issue. When we refer to attribution of a legal entity to a society, the society has its own distinct asset and segregated asset that can answer for these taxing obligations. Now, when we are talking about a robot itself, and therefore the discussion goes to the capacity of contribution, the robot does not have have its own assets and income. So for this taxation to be feasible, it would not be enough to give the robot the legal entity. There would be the need so that it be able to contribute, a capacity to contribute. So therefore, there would be the need of an income. So one of the proposals foresees the attribution of this fictitious income to the robot, to a robot. Therefore, those who be answering for this taxation would be the owner of the robot. It would be an individual or a legal entity which be answering for this taxation, not the robot itself. Nevertheless, attributing to the robot the responsibility or legal entity because of taxation, in case it does not have in its own income. Another question that was brought here by Vicente, if these measures for artificial items has got to do with the income. I do not have any estimate with respect to the taxation impact. The estimate that we have, that we know, are estimate with respect to unemployment, and that bring together the fiscal consequences and income as consumption as a social contribution. Since these estimates vary very broadly according to the study that we are examining, there is a difficulty of the government and institutions that have conducted this study to quantify these tax impacts, because this once again will depend on how many jobs will be lost and how many new jobs will be generated to offset these positions that will then not exist anymore. On the other hand, there is a study which is a bit different with respect to the use or the application of the automation and AI by the fiscal administrations, then with the goal of combating evasion. And also these studies, although they are used for the diverse use of automation, it can generate other positive aspects with respect to what we're talking about now. One of the subgroups at IBDT is dedicated to the study, the application of technologies for the public administration. And I believe that we will have, at the end of all our research, results that will be interesting to share in the next year's Congress. Thank you, Renata. Also, talking about what Silvia mentioned, and also what kind of services could be then treated, like Zoom, for example, of any service of technical content through automation. So, Professor Silvia, I think here we have the answer of your food for thought. So Brazil will probably have taxation on source. So there will be more discussions about this. So I think Durval had a few questions as well. Thank you, Erlan. I have a question for Professor Zilveti. Professor, within the metaverse context, and referring to what Professor Tathiane mentioned in her narrative, she referred to the legal qualification of all these phenomena brought by disruptive technologies. Therefore, I use this narrative and I put forth this question: is there the need to have this legal qualification? Is it necessary? And additionally, the sovereignty of the state and their legal systems, do they have to then comply to this so that they can be, because of the taxation law, the application of taxing in events and phenomena that occur within the metaverse context? How do you, Professor, see this question with respect to metaverse? I would say the following. In metaverse, we have observed a very fast advancements with respect to the legal considerations of several events, even with respect to intellectual property, as mentioned in the panel. For you to have an idea, we have an Institute of Intellectual Property of Second Life. So we have how INPI in Rio de Janeiro that is elaborating about the subject, and we have INPI of Metaverse itself. So there is an evolution, an enormous evolution in the consideration of property with respect to virtual reality. So when I talked to Tathiane or provoked her for this, the NFT is an advancement of the property and intellectual property within the metaverse environment. And on this, we have to understand that although there is this need of every country to accept a consideration or international consideration through the treaties and the Paris Convention, what is intellectual property internally wise, or at least to adhere in part to what is agreed internationally. The Convention of Madrid and Bern, although not having total adherence even before metaverse. So there's got to be a goodwill by the countries to follow this evolution, social economic evolution, and adhere to international treaties. But metaverse does not expect this. The digital environment does not expect this. So to alienate with respect to the considerations of the NFTs, many IRS, like the American one, they understand this as an asset, and they tax it as an asset, as an alienation of assets. Therefore, I do not have the same vision that taxation law is the same. It is not to do with, it is an imposition. And when law does not follow or capture this wealth of the private right, the legal law legislates then this wealth and adjusts this wealth to what matters to the IRS. So excise. Therefore, the normative study gives a treatment for us to see that the acquisition of properties already happened in the metaverse, asset in the metaverse environment. You have to consider it as a crypto active. And understanding it as this, you do your declaration of goods, and then a higher percentage should be set to the IRS. This is advancements that's happening according to the taxation point of view, which is not of a superposition, but of imposition of economic activity, adjusting the traditional concept of property to the virtual concept of property or assets. The answer was very clear. We agree, in fact, with regard to be of an rather than imposition, but first it has to be defined in a clear manner the event that will characterize the generating factor. Since there are complexities in this phenomenon and of this characterization, which so that it's a question of time whether it's going to be an imposition, as Professor mentioned, but this aspect that although it is not the legal qualification and the qualification of this legally wise by the states in an adequate manner, how much this would be the pathway to be followed with respect to the metaverse topic. But the answer is very clear. I'd like to compliment all the panelists. I believe the presentations were extremely focused. They explored the topic in a very competent manner. And therefore, I believe that we covered the proposal of this panel, Erlan, as I mentioned in the beginning, extremely brilliantly due to the characteristics of the panelists. I once again thank you all, and I declare our panel closed. Thank you very much.
Obrigado a todos. Tchau, tchau.